released last year. By seeking to construct a legal regime to regulate AI systems across the board, it is a world first. Its aims are laudable and ambitious: to promote trustworthy AI that is consistent with European values. But will the Act deliver on those noble aspirations? My short answer is, it will not. On its face, the Act appears to provide meaningful legal protection against the threats posed by unregulated AI systems to health, safety, and fundamental rights, but its key operative provisions delegate the task of regulation largely to the tech sector and to AI providers themselves. In other words, we can expect, in terms of the level of protection offered by the Act in Europe, it will be largely business as usual. What remains to be seen is whether the Act nevertheless turns out to be an important foundation that will subsequently be refined and revised to more effectively serve its laudable objectives, or if it serves merely to provide the appearance of legal protection while delivering little in terms of meaningful protection in practice. Only time will tell. So let me begin then by outlining the context in which the proposed AI Act has emerged. Many of you will recall the so-called techlash in around about 2018 as anxiety about the potential adverse impacts of AI emerged into public consciousness and debate. The Cambridge Analytica scandal was quite critical in raising public awareness and galvanizing these concerns. In the meantime, academic interest in the societal implications of AI, which had hitherto been rather niche and marginal, began to explode under the rubric of AI ethics. This suited the tech industry rather well. It fitted comfortably with the extensive PR campaign it embarked upon, developing and publicizing a wide variety of ethical codes of conduct, which the digital tech titans proudly proclaimed that they would seek to uphold. The aim was to reassure us and policymakers that there was nothing to fear. Voluntary self-regulation via ethical codes could be relied upon to address concerns about the perceived ill effects of AI, and basically the tech industry could be trusted to mark its own homework. But it became increasingly politically untenable for European policymakers to sit around and do nothing. But one of the dilemmas facing EU policymakers is a belief that in geopolitical terms, the development and take-up of AI is a race in which the eventual winner would acquire world domination, masters of the universe, with the US and China battling it out for first place. How could action be taken to support European firms to compete more effectively on the global stage without stifling innovation, while assuaging concerns of the European public that more needed to be done? Well, the answer was to convert its perceived weakness into an opportunity by making a virtue of its democratic values, creating a unique brand of AI infused with and designed in accordance with European values, denoted by the moniker Trustworthy AI. So in 2018, the European Commission recruited a group of experts, largely from industry, but with a handful of representatives from academia, including myself, and civil society, chosen in open competition to form the EU's high-level expert group on AI. It began convening in mid-2018, and it issued 2 publications in 2019, the Ethics Guidelines for Trustworthy AI and the Investment and Policy Recommendations for Trustworthy AI. Less than a year later, the European Commission issued a white paper outlining a legal framework intended to regulate AI based on European values and fundamental rights, which aims to give people and other users the confidence to embrace AI-based solutions while encouraging business to develop them. So it's against this backdrop that the EU's proposed AI Act was published in April 2021, and it's now currently wending its way through the EU's tortuous legislative process. This Act follows the basic approach of the White Paper, with some significant refinements, and its recitals are littered with aspirational statements about the need to protect and safeguard European values from the risks posed by AI. However, interestingly, only risks to safety and to fundamental rights are operationalized as explicit regulatory objectives in the Act, departing from the high-level ethics group's guidelines and the Council of Europe's policy initiatives on AI, which are guided by the triumvirate of principles upon which constitutional democracies rest, namely respect for democracy, the rule of law, and fundamental rights. Nonetheless, the Act suggests that European policymakers now recognise that left to its own devices, the market cannot be relied upon to protect the fundamental values upon which the European project is founded from the potential threats generated by unregulated AI applications. So I very warmly welcome this belated recognition of the need to bring the design and operation of AI technologies under law and its laudable objectives, marking an important move beyond the rubric of AI ethics. But whether the proposed Act, assuming it's passed into law, in fact delivers on these noble values will depend upon how those aspirations are operationalised within the Act, particularly its regulatory architecture and the concepts and mechanisms through which it's intended to work. Well, I'm afraid I don't have time today to provide you with a comprehensive overview of the Act, so instead I just want to highlight 3 structural features. Firstly, it adopts a horizontal approach, regulating AI systems in general within the EU, rather than pursuing a sector-specific approach. As you know, there's so much debate about how to define AI. For the purpose of the Act, an AI system refers to a software that's developed with one or more of the techniques and approaches listed in Annex 1, and can, for a given set of human-defined objectives, generate outputs such as content, predictions, recommendations, or decisions, influencing the environment they interact with. The most demanding legal obligations are placed on AI system providers, but more modest legal obligations are also imposed on users of AI systems other than for personal, non-professional use. Secondly, the Commission describes the Act's approach as risk-based, classifying AI systems and/or practices into a series of graded tiers with proportionally more demanding legal obligations that vary in proportion or in accordance with the Commission's perception of the severity of the risks they pose. Risks for this purpose are defined in terms of risks to safety and or to fundamental rights. And so you see, the regime is clearly permissive rather than precautionary, relying on ex post oversight rather than pre-market approval by a public agency, quite unlike the way in which medicines are regulated in Europe. Excuse me. Thirdly, its enforcement and compliance architecture delegates many of the crucial functions to the very actors whom the regime purports to regulate and to other tech industry experts. So while at first glance the Act appears to adopt a public enforcement framework in which national supervisory authorities designated by member states play a primary role, as well as the new European AI Board that will operate in an advisory capacity, supported by powers of investigation and sizable administrative penalties for violation, as I shall shortly explain, in fact, these public authorities are twice removed from where the real action, the real compliance checking and standard setting takes place by relying heavily on the EU's new approach to standardisation. So, before I focus my remaining remarks on standalone high-risk AI systems and how they're regulated under the Act, let me briefly summarise the 5 distinct risk categories that the Act employs. So you see at the very top we have in red prohibited practices under Title 2. This refers to practices that seek to subconsciously manipulate people via subliminal techniques, those that exploit the vulnerability of children or the disabled persons in ways likely to cause harm, and social scoring by public authorities. Then you have in this rather awkward pink box what I call very high-risk systems that are either intended as a safety component of products that are subject to existing third-party ex-ante conformity assessment, or remote biometric identification systems used in public by law enforcement authorities. Then you have this orange area. These are standalone high-risk systems regulated under Title 3. They refer to systems with mainly fundamental rights implications, as we shall shortly see, and it's the regulation of these systems that I'm going to focus on today. So I'll say more about them shortly. In the grey area, you have your medium risk systems. So these are AI systems intended to interact with natural persons. And here, there's an obligation to disclose that you're dealing with an AI system rather than a human, and users of emotion recognition systems or biometric categorization systems. And again, these are transparency obligations where those who are subject to these systems must be informed. Everything else is in the green area. These are all other systems. They don't attract any legal obligations under the Act, although the Commission is keen that there will be voluntary codes of conduct, and this is supported in the Act's framework. So now we're in a position to examine how these orange ones, these standalone high-risk systems, are regulated, and I'm going to focus just on these because arguably they constitute the centrepiece of the regime and perhaps the most controversial. So I guess the first question to ask is, what do we mean by a standalone high-risk system? Well, the definition is provided quite explicitly. That is either a component of a product falling within EU health and safety harmonisation directives, so that's toys, aviation, cars, medical devices or elevators, or falls within a specific and exhaustive list of application areas that are intended to be used for a specific set of purposes, which is set out in Annex 3. So you can see them listed there: biometric identification and categorization, the management and operation of critical infrastructure, education and vocational training, employment, worker management or access to self-employment, access to enjoyment of essential private services or public services and benefits, law enforcement, migration and border control measures, administrative justice and democratic processes. So all of these, you can see, are not primarily about risks to health and safety. They're primarily concerned or may generate fundamental rights concerns, and that's why it's a real test of how this regulatory regime will work. If your AI system falls within this basket, then they must comply with the essential requirements set out in Chapter 2, and those who provide these systems must comply with the obligations set out in Article 16. So, just to try and make sense of these essential requirements, I suggest that we can group them, broadly speaking, into three kinds. So those in the middle, the yellow, are basically technical functionality requirements. The ones on the left, in the orange, concern the establishment and maintenance of a quality management system, and the ones in the green on the right are procedural and cooperation obligations imposed upon providers. So let me say a little bit about each. Excuse me just for a second. Sorry, there's a lot of content because I have to explain the law before I critique it. Right, so let's just quickly race through these technical functional requirements in the yellow. So these are largely concerned with the technical aspects of the software. So under Article 16A, they impose obligations on providers to ensure that the system complies with the Chapter 2 requirements. So these concern matters like the use of high-quality data for training, validation, and testing. And so the data must be free from error, it must be free from bias, it must be suitable and representative. There are a series of transparency obligations, so there must be sufficient disclosure so that users can interpret the outputs and use the system as intended. Quality measures concerning accuracy, robustness, and cybersecurity need to be disclosed, as well as any foreseeable misuse and risks to health and safety or fundamental rights, any changes to performance at the moment of the initial conformity assessment, as well as the expected lifetime maintenance and care measures to ensure proper functioning. There need to be human oversight measures, including appropriate human-machine interface tools that can be effectively overseen by natural persons, aimed at minimising risks to health, safety or fundamental rights, and obligations to ensure the appropriate level of accuracy, robustness and cybersecurity, as well as performing consistently by design in light of their intended purpose. So you can see that these are all, broadly speaking, concerned with technical trustworthiness. They can be expected to provide assurance that the software will function as stated and as intended, and that key performance metrics are disclosed, and so that we can expect the software to perform in a reliable, consistent manner, without bias and in accordance with provider claims about system design and performance metrics, and so helps to address the inherent opacity of software. So to the extent that reliable, consistent software performance is a prerequisite for facilitating safe and rights-compliant AI, these are welcome requirements. But these requirements are not, however, primarily directed towards guarding against the risks or dangers that the Act specifically states it's intended to protect against. They're not principles that any human rights lawyer would recognise, and nor do they say anything about the potential dangers to health and safety. And that's where the second set of obligations kick in. Here in the orange on the left, the critical regulatory technique through which the Act seeks to protect safety and respect for fundamental rights is via the legal obligation of providers of high-risk systems to establish and maintain a quality management system that complies with Article 17. And this quality management system must include a risk management system in which the relevant risks are defined as risks to safety and risks to fundamental rights as an Article 9 essential requirement. So for this purpose, there are some requirements that the risk management system must meet. So it needs to identify and analyse known and foreseeable risks. It needs to implement risk management measures such that any residual risk associated with each hazard and the overall residual risk is judged acceptable if used as intended or under conditions of reasonably foreseeable misuse, and these risks are communicated to the user. I'll say more about that shortly. The risk management system needs to test or ensure that there is the testing of the system prior to it being placed on the market or put into service to identify the most appropriate risk management measures, and the provider needs to draw up and retain technical documentation and ensure that when under its control, the system automatically keeps logs of operation. Thirdly, we come to the set of obligations in the green. The high-risk AI provider needs to undertake various action to enhance transparency about the system and provide public assurance that it meets the Act's requirements. And so this includes ensuring that a relevant conformity assessment process is undertaken before it's placed into service, and to affix the CE mark to the system to indicate conformity. Again, I'll say more about that shortly. To register the system with the Commission's EU database and high-risk systems, to inform national competent authorities that the system's placed on the market or put into service, and if any known risks emerge, to immediately advise the authorities and so forth, and upon request by a national competent authority, to demonstrate conformity of the system with the Chapter 2 requirements, including granting access to automated logs under its control. So, you're probably thinking, yeah, okay, fine, this is all very dull, technical, legal detail. It's true, but I'm afraid you need to understand it before you can critique it. What you really want to know, however, is whether the Act will in fact ensure that AI systems in Europe will be designed, developed and implemented, and in a way that duly protects the European values in accordance with its claimed aspirations. In other words, how protective is the Act against threats to fundamental rights and to safety? Well, in order to evaluate this, we need to think about the scope, content and strength of legal protection. We need to examine more carefully the two-tier system through which safeguards are intended to work, known in regulatory studies parlance as meta-regulation, sometimes also called management-based regulation or enforced self-regulation. This is a regulatory technique in which Christine specialises, in which legally binding obligations are imposed on regulated organisations, requiring them to establish and maintain an internal control system that meets broadly specified outcome-based legal objectives. So meta-regulation is based on the idea that one size does not fit all, and that firms themselves are best placed to understand their own operations and systems and take the necessary action to avoid risks and dangers. So the primary safeguards through which the Act works relies on risk management systems within the regulated organisation, which retains considerable discretion over its own internal systems of management and control, provided that the Act's legally mandated objectives are met. Well, meta-regulation is a well-established regulatory technique. The most well-known is found in health and safety regulation in the UK, copied widely elsewhere under the Health and Safety Act 1987. It's also used, however, for a number of safety-critical industries in a more demanding form known as a safety case approach, quite familiar in Australia, for example, and is used to regulate offshore petroleum. So high-risk AI systems are then legally bound to establish and maintain a risk management system that reduces and manages residual risks to an acceptable level, but the substantive content, contours and practical operation of that risk management system is left to the AI system provider to determine. So what can we say about meta-regulatory approaches based on past experience? Well, in fact, they have been demonstrably successful but only under several quite demanding conditions. Firstly, congruence between the substantive content of the legal standards that providers must comply with, the goals of the regulated firm's internal control system, and the overarching policy goals of the regulatory regime. For Julia Black, a leading regulation scholar, meta-regulation's fundamental weakness is that firms' systems and processes are designed to achieve their own goals, not necessarily those of the regulator, and it relies on firms' processes, systems, controls, and internal culture to work. The problem is that these assumptions may not be borne out in practice. She points to the meta-regulatory strategy adopted by the now defunct Financial Services Authority prior to the global financial crisis, in which the regulator assumed that because it was in the bank's interests to manage their risks well, that regulators and the general public could rely on banks' own internal management systems to ensure this. But the global financial crisis showed that this assumption was deeply flawed, indicating that firms were not as competent in managing themselves as either regulators or firms themselves had assumed, and the incentives were not clearly well aligned with those of regulators. And she says, and I quote, "The crisis demonstrated that regulators were not relying on firms' internal systems and controls as such, but on skillful representation of those systems and controls constructed by those responsible for managing relations with regulatory bodies. Management-based regulation," she says, "was shown to have been myth-based regulation." Well, the second condition that meta-regulation needs to comply with to be effective is the need to impose a general duty of care on regulated firms, legally requiring them to ensure that their internal risk management systems reduce the level of risk as low as reasonably practicable. This is the well-known ALARP standard. As Andrew Hopkins explains in relation to safety cases, a general legal duty of care must be imposed on operators in order to preclude arguments based on legal technicalities, to give the public regulator leverage to require further action if the firm's risk management systems fail to meet that standard. It means that operators can't claim that they've complied if their risk management processes are demonstrably inadequate, and it means that if there is a serious safety failure, that it's relatively easy to prosecute the firm concerned. But if we compare the legal duty imposed under health and safety laws with the duty imposed on high-risk AI providers, we see that the latter is much, much weaker than this ALARP standard. So although the ALARP terminology may appear vague and imprecise, what does it mean to be as low as reasonably practicable? Interpretation by the courts has generated an established body of case law that now provides fairly clear guidance concerning what the general duty requires in particular cases. And it requires the adoption of effective precautions unless there is a gross disproportion between the level of risk and the cost of taking particular precautions to reduce that risk. In contrast, under the AI Act, the duty of high-risk AI systems providers is merely to ensure that the residual risk associated with each hazard, as well as the overall risk, is judged acceptable. It doesn't even require that the reduction of risks is reduced to a reasonable level. This choice of terminology, I suspect, was clearly intentional. It suggests that the judgment of acceptability is to be understood in a subjective fashion from the perspective of and determined by the high-risk AI provider. In short, the level of legal protection to fundamental rights and to safety is relatively weak, particularly compared with the level of safety that is required under health and safety legislation. But even if a considerably more demanding standard had been employed, the lack of meaningful and effective enforcement mechanisms suggests that it's unlikely in practice to meet these standards anyway. And this brings me to the third requirement for effective meta-regulation, notably a requirement on the regulated organisation to make the case. That is, to demonstrate and to explain to a well-resourced, competent, independent regulator that the organisational measures and methods taken to identify and measure the risks and the reasoning adopted in favour of choosing one control measure or over another can be justified. Otherwise, if there isn't this obligation to explain, to a public independent regulator, then there's a serious danger that the evaluation of these risk management systems will be merely a rubber stamping exercise. This was vividly exposed in the Deepwater Horizon disaster, where the relevant regulator was conducting no meaningful or effective inspections or exercising oversight, having been starved of resources, lacking in expertise, and therefore we have the greatest single event environmental disaster in human history. There's nothing close to effective and meaningful enforcement, I'm afraid, in relation to the Act, and that's because it's based on the new approach to standardisation, and to which I now turn. So to understand, excuse me for a sec, where the real action will occur, we need to look more closely at two things. Firstly, the Act's enforcement and compliance architecture and the process for setting standards, because these things will dictate how the regime operates in practice. So it's helpful to understand a little bit more about the new approach to standardisation. It was introduced in 1985, intended to open up European markets in industrial products without allegedly threatening the safety of European consumers, by allowing the entry of industrial products across European markets if and only if they meet essential requirements set out in sector-specific European directives developed by one of the three European standards organisations, that is CEN, CENELEC and ETI. Producers can choose either, and this is quite important, to try and follow the EU directive themselves and try and make sense of it, or they can rely on the harmonised standards produced by one of these standard-setting bodies. So it's a two-stage approach that combines compulsory regulation under the directive and voluntary standards made by European standards organisations, which are essentially private, non-governmental bodies comprised of technical experts, largely from industry. Central to this new approach is that the conformity of products with the essential safety requirements is checked and certified by the producers themselves, who make a declaration of conformity and affix the CE mark to their products to indicate compliance, and then the product can go forward and be marketed and sold across the entire EU. Although for some sensitive sectors, or sensitive products within a sector, assessment of conformity with the harmonised standards is undertaken by an independent third-party certifier, known as a notified body, an independent but nonetheless private organisation which must undertake a conformity assessment before a conformity certificate can be issued and the CE mark affixed. And it's the producer who pays for the certification service, and this has led to a flourishing market for certification in response. Importantly, compliance with the harmonised standards is entirely voluntary. If producers choose to follow them, however, there is a presumption of legal conformity with the essential requirements once the harmonised standard has been cited in the official journal of the EU, and this typically enables producers to benefit from a simplified conformity assessment process. So even though compliance with these standards is voluntary, producers are in practice strongly incentivised to follow the technical standards rather than carry the burden of demonstrating that their own technical specifications meet the essential requirements. So what does this all mean for a high-risk software system provider? Well, let's consider the position of say, a medium-sized software provider that's developing and selling AI-enabled digital software solutions to government, let's say to help manage public service delivery. Well, in the absence of harmonised technical standards, how would such a firm go about trying to comply with the Act, particularly the Chapter 2 requirements? Well, here they face considerable difficulties because these requirements are expressed in broad, relatively open-ended terms. And it's into this interpretive grey area where the rubber really hits the road, in which the operative provisions will be given meaning and translated into practice. And here three terms are particularly important. The concept of risk. So even though risk to health and safety is a familiar and well-established concept within legal parlance and regulatory regimes, the Annex 3 systems are more likely to interfere with fundamental rights. But what precisely is meant by a risk to fundamental rights, and how should those risks be assessed? Secondly, even assuming that risks can be meaningfully assessed, How then is the software firm to evaluate what constitutes a level of residual risk judged adequate? And thirdly, what is a risk management system that meets the requirements of Article 9? Well, each of these three challenges is rooted in the interpretive ambiguity associated with key terminology. For lawyers, this is a very familiar problem and quite typical of any regulatory regime associated with the use of rules. Indeed, you could say it's our core business. And this is inescapable. As Austrian philosopher Ludwig Wittgenstein has observed, this kind of ambiguity is an inherent feature of human language due to its inescapable indeterminacy. Well, this poses challenges when seeking to formulate rules to guide behaviour, particularly the extent to which one formulates rules in a detailed manner or in much broader, more open-ended principled terms, because it presents a number of trade-offs. And every parent is familiar with these. So in theory, the principle, do unto others as you would have them do to you, should provide adequate guidance to my children concerning their behaviour to other people. But of course, in practice, they typically require much, much more detailed guidance than that. And due to the value that they place on legal certainty, regulated firms are much more likely to prefer narrowly specified detailed rules because they offer much more concrete, specific guidance about what they need to do in order to comply. But interpretive ambiguity is unavoidable when new legislation enters into force, and here, administrative guidance provided by a public regulatory agency conventionally plays an important and very familiar role. So, for example, under the GDPR, which contains a number of broadly defined principles, are legally binding on data processors and collectors means that as a result, both the European Data Protection Board and national data protection authorities, all public regulators, have issued a number of guidance documents, and they continue to do so, offering interpretive guidance about what the law requires. Note that compliance with this interpretive guidance doesn't guarantee compliance with the law because it doesn't bind the courts when they interpret the law authoritatively. But nonetheless, it's valuable, it's reasonably authoritative assistance for those seeking to comply with their legal obligations. Importantly, this guidance is open, published, transparent, and conventionally issued in draft form beforehand so that stakeholders and the public can provide feedback before it's issued in final form, and so it's consistent with principles of accountable democratic governance. But this isn't the way in which the key legal terms will be interpreted and applied under the Act. Why? That's because this task has essentially been privatised, thanks to the EU's new approach to standardisation. And so Article 40 provides that high-risk AI systems which are in conformity with harmonised standards published in the official journal shall be presumed to be in conformity with the Chapter 2 requirements. Well, I'll say much more about CENELEC as the relevant private standard-setting body shortly, but for now the key point to emphasise is that the Act is designed so that high-risk AI providers, except for remote biometric systems, can either attempt to interpret and apply the Chapter 2 requirements themselves, possibly with some legal advice, or they can adhere to harmonised standards once they're published and enjoy a presumption of legal conformity in compliance with Chapter 2. So no prizes for guessing what software providers and tech firms are going to choose. In other words, we can expect that in practice, the harmonised standard produced by CENELEC, which is already working on this standard, will become the de facto and de jure legal standard and thus determine the nature and level of protection under the regime. It allows providers to self-assess their own internal controls, sign and lodge a conformity assessment declaration, stick the CE mark on their software, notify the Commission, and to use the Australian vernacular, Bob's your uncle. In fact, if the provider has made no attempt to comply with European standards, no one will be any the wiser, unless and until action is taken by a market surveillance authority to evaluate the system's compliance. And it can't do this unless it has sufficient reason to consider that the AI system presents a risk to health and safety or the protection of fundamental rights under Article 65. So what I wanted to emphasise here is that it's up to AI providers themselves to self-certify that they have conformed with the Chapter 2 requirements. Will this really produce trustworthy AI? It's pretty obvious that I seriously doubt it, particularly given that several studies have found that products that have been self-certified are considerably more likely to fail to meet the certified standard. So, for example, in a 2018 study comparing toy safety recalls in the US, which requires independent third-party verification and certification, and the EU's toy safety regime, which relies on self-assessment, over a 2-year period found stark differences, with toy safety recalls in the EU 9 to 20 times greater than in the US. This aligns with earlier policy studies that find that self-assessment models consistently produce substantially higher rates of worker injury compared with those involving third-party independent evaluation. And so Larson and Jordan conclude that transnational product safety regulatory systems that rely on self-assessment of conformity fail to keep products which don't comply with those standards off the market. But even third-party certification under the new approach, which is shown to be better under their standards, is itself pretty weak and ineffective, evidenced by the EU's medical device regime. This was vividly illustrated by the PIP breast implant scandal, in which approximately 40,000 women in France, and possibly 10 times more worldwide, received breast implants filled with cheap industrial-grade silicone rather than compulsory medical-grade standard required by EU law, even though the implants had been certified as CE compliant by a large and reputable German certification authority. And this was possible because under the relevant directive, breast implant producers could choose between different methods of inspection by notified bodies. PIP had chosen the full quality assurance system, and basically that meant just check the paperwork. So it was the certifier's job to audit PIP's quality management system without having to inspect the breast implants themselves. In short, the new approach has succeeded in fostering a flourishing market for compliance regimes and certification services, but it has failed to protect European patients and consumers from untrustworthy products and services. And so I share software expert Martin Thomas's scathing view of CE marking, at least for safety-critical systems and services, particularly under the former EU medical device regime. I hasten to add that the medical device regime has been reformed. Whether it's any better in practice remains to be seen. So finally, the question that arises, will these standards produced by these ESOs actually foster the protection of safety and fundamental rights? Because in fact, this is where the standards will be set. So it invariably prompts questions about the prospects of these standards aligning with the goals of the Act itself. So I'm just going to finish up by saying a few words about this standard-setting process to give you a sense of the prospects. And to this end, it's helpful to understand the larger context in which transnational technical standard-setting bodies have emerged. They emerged in the early 1980s. Until then, the dominant regulatory regime for industrial products involved national regulators taking responsibility for monitoring and enforcing legally binding national legal standards. But as national markets were liberalised from the 1980s onwards, a wide range of technical standards formulated by expert-based standard-setting organisations alongside the so-called certification revolution began to proliferate. So today, most trade in industrial products internationally is now regulated through tripartite standards regimes with 3 separate phases: standardisation, certification and accreditation. And it's upon this basis that the European new approach to standardisation is modelled. So to evaluate the likelihood that CENELEC will produce technical standards that produce meaningful and effective protection of fundamental rights, there are 4 matters to be borne in mind, and I'm nearly there, I promise. Firstly, it's important to realise that these standard-setting bodies are non-governmental private organisations whose members are comprised of an extensive network of technical experts. So, for example, CENELEC and CEN are international non-profit organisations, and their members are made up of the 43 different national standardisation bodies across Europe, including member states of the EU and other members of the single European market. The standards themselves are developed by teams of experts on technical committees who have specialist knowledge of the sector or the topic being addressed. Secondly, it's important to recognise that technical standardisation processes are highly political. They are not neutral and objective. Even though we typically think of technical standardisation as a mundane objective process undertaken by technical experts, conducted in the highly technical vernacular, insights from STS have vividly demonstrated that standardisation processes are anything but neutral and objective. They are unavoidably political. As Lawrence Bush puts it, standards are intimately associated with power. These standardisation bodies have conventionally been dominated by private sector actors, particularly those with large market share who have the leverage to advocate for standards that align with their own products. And this has led to American tech firms playing the dominant role in shaping global tech standards. More recently, however, recognising the political power to be gained from control of technical standards, the Chinese Communist Party has sought to exert more influence over technical standards, much to the alarm of the US and European governments. So not only does the non-governmental nature of these bodies result in the dominance of well-resourced tech firms, it also means that they are not subject to conventional democratic mechanisms of public oversight or accountability that apply to the conventional lawmaking process. So neither the European Parliament nor member states have a binding veto over the harmonised standards, and even the European Commission has very limited powers to influence their content, which are essentially immune from judicial review. But once finalised and they achieve the status of harmonised standards under the new legislative framework cited in the official journal, then if you comply with them, you are deemed to comply with the law. And rather surprisingly, if you want to see a copy of these standards, you can't find them on the internet. You have to pay for them because they're protected by copyright and they are not cheap. Thirdly, criticisms of the lack of democratic legitimacy of these organisations has led to moves to open up the process to multi-stakeholder dialogue. In practice, these are also seriously inadequate. For example, many of the European stakeholders have very limited rights to participate. They can't vote. They can only access documents, propose inputs, and submit comments and technical contributions, although the Commission has indicated that it's keen for small and medium-sized enterprises and civil society to be involved in this one. Well, what will actually happen remains unknown. And in practice, stakeholder organisations face serious de facto obstacles to participate effectively. Most of them have no experience in technical standardisation. Many lack EU representation. Participation is very costly and time-consuming and can take years because participation is subject to a fee, and therefore, in practice, it's really not much of a multi-stakeholder dialogue. And as my colleague Joanna Bryson has put it, even when technical standards for software are useful, they are ripe for regulatory capture. They tend to be stacked with people from large corporations and with vested interests. Assessing and certifying standards, she says, is also expensive and excluding, working against small and medium enterprises and the developing world. Fourthly and finally, these technical standard setting bodies are populated by experts, but they're experts from engineering and computer science and primarily from industry. They don't have any knowledge or expertise in fundamental rights, let alone are they familiar with the analytical reasoning that's well established in human rights evaluation to determine whether a fundamental right has been interfered with or whether it's been justified. Indeed, when I was on the high-level expert group and we piloted these requirements with firms, most of them were mystified about the question concerning, have you thought about compliance with the impact on fundamental rights? Most of them said, what on earth do you mean? So without a cadre of human rights lawyers to assist them, I'm even more sceptical of the competence and ability of CENELEC to translate the notion of risks to fundamental rights into technical standards. At an even more foundational level, the notion of acceptable residual risk to fundamental rights is, in my view, deeply problematic and potentially antithetical to the very notion of fundamental rights, because they are actually political constructs accorded special legal protection in which evaluation with a possible interference requires close attention to the nature and scope of the relevant right in a specific localised context in which a particular right is allegedly infringed. So I seriously doubt whether fundamental rights can be translated into generalised technical standards that can be precisely measured in quantitative terms. Unlike safety hazards generated by chemicals, machinery or industrial waste, which can be materially observed and measured, and even that's controversial, fundamental rights are social constructs. So I just don't understand how they will be translated into technical standards in a manner that faithfully reflects what fundamental rights are and how they've been interpreted and understood in accordance with European human rights law and jurisprudence. So I'm rather pessimistic about the capacity and prospects of CENELEC, however well-intentioned, to produce technical standards that will, if duly followed, provide a high level of protection to fundamental rights, which the Act claims to aspire to, and yet constitutes deemed compliance with the Chapter 2 essential requirements. In conclusion then, I've argued that the EU's proposed AI Act is unlikely to deliver on its noble aspirational values due to the regulatory architecture and mechanisms through which it's intended to operate, although it's very likely to stimulate new markets for service providers offering quality management systems that purport to comply with the Act's requirements. In closing then, I warmly welcome active measures to bring AI systems under law, and I would warmly encourage Australian policymakers and policymakers elsewhere to follow the EU's lead in that objective. But please, I implore you, if you're going to do it, don't do it this way, because the regulatory architecture through which this Act intends to translate its laudable aspirations into real-world practice is unlikely to deliver what it aspires to. Thank you very much. I'm sorry for all that content.
Thank you very much, Karen. We are into the morning tea time. Nick had informed me we could have a small indulgence for maybe 1 or 2 questions, and I'm looking at Julian and Jean to give me the nod. Thank you. Because I'm sure that tour de force raised many questions. So I'm going to take 2. Paul, a roving mic will come to you.
Karen, for that wonderful overview of the European Union's regulation on AI. As you said earlier, there's a lot of ambiguity in this document. I wanted to unpack one particular ambiguity, which was mentioned in terms of these high-risk ones, which is bias. What is bias, and is it actually defined? Now, I'm asking you this question because right now the Australian government has a draft regulation to outlaw bias in the new employment services model.
Right.
And the way in which it treats unemployed people and its allocation of services. And yet there's no definition in the regulation of what bias is. The lawyers have just said, oh, we just adopt bias. And if you have an ambiguity, how do you possibly regulate that or actually approve that bias has actually happened? So that's the key question.
It's a great question. I don't think you can do an analysis of bias unless you're very clear about what your reference point is. So it sounds like this Act doesn't have any reference point. Okay, so my guess is as good as yours, and there is actually a really helpful report that was undertaken for the CDEI, the Council for Data Ethics and Innovation, which talks about bias in relation to machine learning systems. And it opens up this question. It says, well, it could just be a bias towards technical solution rather than a social solution. And that's absolutely a form of bias. So it really depends on what your reference point is, and it's rather troubling that there's no reference point provided in the Act that you mentioned. So it's a very good question. Good luck with that one.
I might just ask, I've got a question from the online people I thought I might take. And I think it's the $64 million question.
So what should be done? Yeah.
Is there a jurisdiction or academic working on a proposed AI regulatory framework which you think shows more promise?
There's nothing comprehensive that I have seen. There have been some useful measures that have been enacted in relation to the use of AI system in the public sector. But in terms of proposals to regulate in a general horizontal way, akin to the EU's proposal, I haven't seen anything coming close to that.
Okay, so there's a challenge for the ADMS. And one last question here. Would you mind introducing yourself?
Yeah, thank you so much, Karen. My name is Dave. I'm with the Digital Asia Hub. I have a question related to a panel that we'll be doing this afternoon. So the EU's enacted this Digital Services Act and Digital Markets Act. I was wondering if you see any sort of connections with the AI Act and whether that maybe helps enforcement or makes things even more complicated and difficult. Yeah,
yes, it's a really good point, and I haven't said anything about the Digital Markets Act or the Digital Services Act, but it is actually important to see all of these new measures as part of a package for digital reform. I'm not an expert on content regulation at all, but my understanding is that because those measures are much more specifically directed towards the abuse of market power, they have much more scope to have real teeth compared with this particular piece of legislation. And so I'm not going to say anything because I don't know enough about them, to be perfectly honest. I just can't keep up with all of the legislation. But I think you're absolutely right in pointing to other European measures that I think genuinely have more promise, even though they've also been quite heavily criticised from various quarters.
Thank you, Karen, and I won't keep you any longer from your morning tea. Just to say thank you so much for taking the trip all the way back home to Melbourne.
Can I make a little slightly naughty
yes.
point? Is that I'm looking for a postdoc. I thought this was a wonderful place to let you know. Closing date is at the end of August. Thank you. Do come and see me if you're interested.
Yes, and Karen will be here the rest of the conference and happy to answer all your questions about the EU AI Act and into the future, as she is one of our partner investigators. Thank you, Karen.
Thank you.